Now, let's talk about sections 138 and 139. These sections are all about leading questions and written evidence. A leading question is basically one that tries to steer the witness towards a specific answer. Think of it like a lawyer asking, "You were at the crime scene that night, weren't you?" Instead of, "Where were you that night?" Section 138 says you can't generally ask these types of questions during the first go-around with a witness, but they're fair game during cross-examination. Why? Because cross-examination is all about testing the witness's story and seeing if they crack under pressure. Section 139 deals with written evidence. Contracts, emails, grocery lists. If it's written down and relevant to the case, it falls under this section. This section says you can ask a witness about a specific document and even show it to them in court. It seems straightforward, but trust me, things can get very twisty-turny when lawyers start using documents to poke holes in a witness's testimony. Hold on to your hats, folks, because sections 140 and 141 are where things get really juicy. These sections are all about challenging the credibility of a witness. Section 140 deals with previous written statements. Let's say a witness said something in a written statement before the trial that contradicts what they're saying now. Well, Section 140 allows the opposing lawyer to bring up that previous statement during cross-examination. It's a classic gotcha moment in court, and it can seriously damage a witness's credibility. Section 141 is where things get really wild. This section outlines all sorts of questions that are fair game during cross-examination, even if they seem totally irrelevant to the case. Did the witness cheat on their taxes 5 years ago? Were they ever caught lying to their mother? It might seem unfair, but there's a method to the madness. The idea is that if a witness is willing to lie about one thing, they might be willing to lie about anything. Now, before you think lawyers have free rein to ask whatever they want during cross-examination, let's talk about sections 142 and 143. These sections give the court some much-needed power to keep things from getting out of hand. Section 142 says that a witness has to answer all questions during cross-examination, even if they don't like it. Of course, there are some exceptions, like if the question is about something truly irrelevant, or if it would incriminate the witness. Section 143 is all about giving the court the power to step in and say, "All right, that's enough." The judge can decide when a particular line of questioning has gone too far, or if a witness needs a break from the grilling. It's all about maintaining some semblance of order in what can often feel like a very chaotic process.